Good evening. Good evening, everyone. Good evening and welcome to the FCC. You can move a little bit inside so that people who arrive later won't have to cross in front of the camera because we will be live. My name is Florence de Changy. I'm a correspondent with Le Monde newspaper and the president of the club. And I'm delighted to host tonight's book launch. It's a book with a rather provocative title. Is the Hong Kong Judiciary Sleepwalking to 2047? My spontaneous answer to this, of course, was I hope not, but with just a few words I've had with Judge Henry Litton, I understand that the issue is a very serious one. The author asking the question, indeed, is an eminent member of Hong Kong, former Judge Henry Litton. Henry Litton was appointed to the Court of Appeal in 1992 and became a permanent judge of the Court of Final Appeal in 1997. He's now an honorary professor at the University of Hong Kong Faculty of Law, among other things. He practiced law as a barrister for more than 20 years, including 12 as a Queen's Counsel. Henry Litton has also served as chairman of the Bar Association at 3 different times for a total of 7 years. The book launch tonight is illustrated by cartoonist Harry Harrison, who is here, not far, a long-standing FCC member whom we probably all know for his sharp and sarcastic cartoons of Hong Kong life and politics. Mr. Litton will now give a short introductory talk highlighting the key themes in his book, and he will take then some question, and he will not sign his book. Please welcome Henry Litton.
Thank you, President. I would like to open by thanking the Foreign Correspondents Club for providing the facilities for this book launch and for all of you for attending this event. My special thanks go to all those who have helped to make this project possible. My wonderful publisher, Guy Shearer, Sheriff Books, who's lurking modestly somewhere I can't see. My wonderful research assistant, Jeff Y.T. Yao, who's at the moment studying for a higher degree in London, and my most meticulous printer, Mr. Joseph Tam, and his company, Offset, Rising Offset Printing Company. Now, if there should be any infelicities in the book, they're all mine. Within the great nation of China, Hong Kong has a very special place. And it is unique in the common law world. For about 1.5 centuries, Britain had a great empire. When the tide of history receded, it left behind an effective and robust legal system which governs many Asian countries to this day, long after they had gained independence from colonial rule. Pakistan, India, Sri Lanka, Malaysia, Singapore, Brunei, the island nations in the Pacific, and then of course there's the United States of America, Canada, Australia, New Zealand, many African countries, and many nations, island nations in the Caribbean, and there's Hong Kong. Unlike all the other common law countries, the Hong Kong common law system has a shelf life. Like Cinderella's golden carriage, it turns to pumpkin on the last stroke of midnight on the 30th of June 2047, unless the fairy godmother waves her magic wand again. Last time, 45 years ago, when Hong Kong's governing system and lifestyle were in issue, the decision makers were the two sovereign powers, China and Great Britain. And what wise and far-sighted people they were, who carried out their broad mandate. But this time round, when Hong Kong finds its future once more in the balance, maybe no more than 10 years from now, it will be standing alone. It will then be up to the Hong Kong leaders to put the case for Hong Kong, to advocate for existing governing system to remain unchanged. Now, can it be assumed, or should it be taken for granted, that the common law system would be extended for another 50 years, 100 years, beyond 30th of June 2047? Now, the common law lies at the foundation of every institution and activity in Hong Kong, social, economic, and political. The debate going on right now, whether Hong Kong should move towards a wider form of democracy, would have no meaning if the common law were not at its roots. The common law is an effective legal system because it has always been a pragmatic one. Its focus is always on remedies and on practical results. It is summed up in one phrase: there is no wrong without a remedy. Or perhaps better expressed in Chinese, 有救濟方為權利, which translated, I suppose, means something like appropriate, effective remedy alone confers legal rights. Now, that was the system which China and Britain agreed in 1983 should be the governing system in Hong Kong after the handover. But slowly, insidiously, over the past 20-odd years, that system has lost its effectiveness. Court proceedings tend to be dominated by lawyers' arguments. The real issues get swept away in the flood of words. Common sense gets submerged. Take the most recent example, the co-location scheme at the West Kowloon Rail Terminal. After the most meticulous study and discussion by the government bodies concerned with the project on both sides of the border, the Legislative Council passed the Guangzhou, Shenzhen, Hong Kong Express Rail Link brackets co-location close brackets ordinance. Now, this was assented to by the Chief Executive on the 27th of December 2020, on the 21st of June last year. It followed the Standing Committee of the National People's Congress's declaration of the 27th of December 2017, approving the arrangement, including the setting up of a mainland port area within the West Kowloon Rail Terminal, stating unequivocally that it was consistent with the PRC Constitution and the Basic Law. And the ordinance gave effect to that arrangement as approved. On the 23rd of September last year, the project was officially launched and the trains started running. All immigration, customs and quarantine procedures, whether by Hong Kong or mainland officials, took place within the terminal building. For obvious reasons, those processes performed by the mainland officials followed mainland laws and procedures. For equally obvious reasons, within the mainland port area leased to the PRC government, mainland laws applied. Now then came an attempted constitutional challenge by 4 individuals. And I emphasize the word attempted challenge. Eventually, 12 barristers, 6 of them senior counsel, with their attendant solicitors, appeared before a High Court judge and argued the matter for 2 whole days, 30th and 31st of October last year. By then, the trains had been running for more than a month. And when the judge came to deliver his judgment on the 13th of December, the trains had been running for nearly 3 months. Now, the judgment is massive. How many of you actually have read that judgment from cover to cover? 1. Yes, of course, Professor Johannes Chan would have done so. Well, congratulations to 2 of 100 or so, or 3. Oh, Alvin, well done. You've read it too? Oh, good for you. Well, you know, then it's 56 pages, right? Such earnest effort, such hard work, but so misguided. Now, it gives a comprehensive history as to how the Express Rail Link scheme was conceived. It details how the problems, legal and practical, were resolved by meticulous planning, resulting in a high-speed system linking Hong Kong to the national network on the mainland. The judge concluded his judgment by saying that the arrangement for co-location, amalgamating all the immigration, customs and quarantine facilities in one building, was, as he puts it, reasonable and, quotes, made good sense. No one would have disputed that proposition. Now, you would think, would you not, that the judgment just ended there. It made sense. You'd be wrong. For the judge then added, quotes, whether it is legally permissible is a separate issue, which I shall consider later in this judgment. And by Jove, he certainly did, 40-odd pages of it. In other words, a massive infrastructure scheme involving the mainland, expending billions of taxpayers' money, requiring years of planning and more in construction, approved by the Standing Committee, which declared it to be consistent with the Basic Law, underpinned by a Hong Kong statute, built, operated and running, might still be nullified by a single judge sitting in Hong Kong. Now, what kind of tyranny does this imply? What? The judge emperor pronounces and you tremble and obey? Is that the scene? Such an approach to the case negates democratic principles and it defies common sense. It is not that of the common law, not even of Strasbourg law. It is Frankenstein law. If it be correct, the courts have bred a monster so grotesque, so powerful, that it is capable of consuming its own body politic and destroying the very structure that housed it. Now, the 4 individuals who sought leave from the judge to start proceedings had no more interest, no greater standing in the Express Rail project than you or I. And yet, they purported, in effect in our name, to strike down a scheme which took years of hard work and hard thinking to mature, not to mention billions of dollars. Now, the judge began his judgment by saying that the issue before him was whether the ordinance was inconsistent with the Basic Law. By that one sentence, he revealed his failure to grasp the significance of his own constitutional position, for that was not the real issue before him. What he had before him were mere applications for leave to start proceedings and nothing more. If the discipline of law were observed, those applications would have been heard by a judge in chambers. On receiving the papers, including Form 86, by which leave to start proceedings was initiated, the first consideration in the judge's mind should have been what practical remedy was possible. His thoughts should have been along these lines. Here I am, reading these papers in my room. Outside, people are going about their own business, moving in and out of the immigration halls at West Kowloon, boarding, exiting trains. The trains are running to strict timetables, and thousands, maybe tens of thousands of people are involved. Now, you, the applicants that I see on the papers before me, say that the ordinance underpinning the entire scheme is unconstitutional. You say that you are an aggrieved party and seek my permission to start proceedings. Assuming at the end of the day you are found to be right, what remedy do you seek? What order do you say I should make? What? A formal declaration from me that the ordinance passed by the Legislative Council and signed into law by due process is unconstitutional? A declaration to that effect? But those are just words, mere words. What consequence do you say follow from those words? What? Close down the entire operation? Stop the trains? Kick the mainland officials out of the mainland port area? No, well, if that's not the consequence you seek, then what is the point of these applications? Now, either those proposed proceedings for which these applicants sought leave have real consequence or they don't. There cannot be two ways about it. There's no halfway house on the issue. Either yes or no. What was before the judge, as mentioned earlier, were mere applications for leave to start proceedings. Now, at that point, no one but the applicants themselves were involved. But if permission were given and judicial review proceedings would then start and would affect not only the applicants, but everyone else in Hong Kong and in the mainland. Now, judicial review is concerned with process, with practical public affairs. Remedy is discretionary, exercised always in the context of good governance, proper administration in the best interests of the community. No common law jurisdiction in the world would allow such a proceeding to destroy good governments, violate proper administration, wreak havoc within the community. If the judge had given a moment's thought to his true constitutional position, he could never have entertained argument from counsel as to whether the ordinance conflicted with the basic law. Quite apart from the fact that the Standing Committee's statement was unquestionably binding on him. So the entire exercise in court was pointless. Now, the sad thing was that counsel for the government, instead of reminding the judge of his true constitutional position, himself played the applicant's game and matched argument with argument. The 2 days of argument in court were just a carnival of words, a lion dance, mole or mosi, with counsel on both sides, for and against the government, in the role of acrobats, dancing ritualistically before the judge. The lion had no teeth. It was an elaborate charade signifying nothing except the vacuousness of court proceedings. It was a total farce. Now, another grotesque aspect of the hearing is this. Two, quote-unquote, experts were called as witnesses, Professor Wang Lei and Professor Fu Hualing, learned men, no doubt, to debate whether the National People's Congress Standing Committee should have issued an interpretation, under Article 1581 of the Basic Law, or a decision, quyết định. The judge devoted nearly 6 pages of his judgment, right? 6 pages of his judgment on this matter. The notion that the case could have turned on such a fine distinction is absurd. Moreover, the judge himself, in paragraph 58 of his judgment, said in effect that the Court of Final Appeal had already in previous cases brushed aside such distinction, holding that Article 1581 was, quote-unquote, freestanding, and that the Standing Committee's powers of interpretation were unqualified. So why court time was taken up with such a matter is incomprehensible. And the remarkable thing is this: the judge's jurisdiction to entertain the so-called constitutional challenge comes from Section 21K of the High Court Ordinance. Subsection 3 says, and I quote, "The court shall not grant leave unless the applicant has sufficient interest in the matter," unquote. As mentioned earlier, these applicants had no greater interest in the express rail link than you or I. And yet, their standing in the matter, which appears politically motivated and nothing else, was never challenged. The Chief Justice, at the formal opening of the legal year, referred to courts having to adjudicate controversial political or social events, and he said, quotes, "It would be strictly speaking inaccurate to say that courts are caught in the middle when they are called on to handle such types of cases," unquote. The question whether courts are caught in the middle would not arise if strict discipline of law were observed. Now, this case, alas, typifies some of those with which my book of essays deals. In those essays, some other judgments by my former colleagues come under scrutiny. In them will be found pronouncements upholding the norms of open, liberal, democratic societies where freedom of expression is highly valued. They also rely heavily on statements by the European Court of Human Rights, which once said, quotes, "The right to freedom of expression applies also to those that offend, shock, or disturb the state or any section of the population. Such are the demands of that pluralism, tolerance, and broad-mindedness without which there is no democratic society." I'm sure that my former colleagues will view these essays with the same tolerance and broad-mindedness, and I hope with acceptance. Thank you.
The floor is open to questions. So if you have some, please introduce yourself and ask a question. Maybe I could start with the first one, asking Mr. Litton. How do you think the Hong Kong system that you describe unhappily got there? Why is it that we are in this situation where the court is not dealing the way you would like it to act?
I think you will actually, I think, have to read the epilogue to the book, where I try to outline where, as I put it, the rot set in. It began quite early on, where the wrong path was taken. And instead of viewing the Hong Kong Bill of Rights as a piece of domestic legislation, the courts were persuaded by counsel to view it as an entirely new game in town, and to properly interpret the Bill of Rights, which is expressed in Chinese and in English, of course. You don't simply look at the words of the statute. You also look at how equivalent ideas overseas, particularly in Europe, interpret them. And one of the points I make in the book is this. Yes, it's true, the Hong Kong Bill of Rights is derived from the International Covenant on Civil and Political Rights. And yes, it's signed by over 100 countries. In fact, 172 countries, as to, up to today's date, have subscribed to it. And therefore, if you actually try to incorporate all the values and norms of hundreds of countries, not confined, of course, to the common law, you have to use rather loose language. But whatever language you use, when it comes to a Hong Kong statute, you interpret the law by Hong Kong criteria, the common law. And it's only in extreme cases where really you can make no sense at all of an article, say, in the Bill of Rights, do you have to resort to overseas jurisprudence. But then, when you say overseas jurisprudence, why confine it to Europe? Now, as I put in the book, Turkey is a signatory, Japan is a signatory. Why not look to see how similar words in Turkey or in Japan is interpreted? Or Poland, or any of the African countries. So this is does that help to explain why, this...
How we got there, yeah, and also, is it repairable? Does it take awareness and political decision from the justice minister or someone like that, or no, is it just a trend?
Well, I hope it will not require the intervention of the executive. I would have thought that, as you mentioned just now, awareness. I think the short answer is that maybe, we're all too busy, you see, to reflect, to pay attention. How many people actually can spare the time? 3 out of how many people have read the judgment? And if you don't read the stuff, you can't begin to understand what's been going on. And the Congo judgment is 195 pages. Now, if there ever was a judgment that affects, relationship between the mainland and Hong Kong, you think that it would have been the Congo judgment. Now, how long do you think it would have taken that 195 pages in English text to be translated into Chinese? It's just one judgment. Doesn't this illustrate what the point that you just made? Awareness. I think that's the first issue.
Thank you. Next question? Keith?
Hi, Keith Richburg. I teach journalism at HKU. So what's your opinion of the new law that will make it illegal to insult the national anthem, and how does that square with the Hong Kong rights to free expression? Now,
look, at the end of the day, I'm a lawyer, okay? And until I see the hard text, I'm not prepared to make any comment.
Next question? Come on.
Here's a revolutionary who's going to stir it up.
No, my dear Henry. I'm just trying, as my own observation, I don't know, not so close. I think my voice is loud enough. My own observation is, being in Hong Kong for some time now, the legal system and the political orientation seems to be kind of fused together. When you talk about legal system, legal this, legal that, but a lot of people in Hong Kong, even within the legal profession, are actually swayed by their own political thinking in the relationship with the mainland. What's your comment on that?
No lawyer can answer a question like that.
Can you be more open up your thinking? Besides confine yourself being a lawyer, can you have other common sense commentator that we'd like to hear?
My dear cousin, the whole thrust of my book of essays, the whole thrust of what I've been trying to say is that one has to be focused on real issues and not to speculate philosophically. And what you're asking me to do is the opposite of what I've been advocating, and obviously I've totally failed as far as you're concerned.
Dear cousin, I know you're terribly limited by your legal profession, etc., etc. I, being an old-timer, old journalist, there are no boundary for what we want to know. And here you are standing in front of us. Can we ask you any question that's in our mind?
You think of me as the sort of the oracle, all-knowing, all-seeing. Well, I'm afraid I cannot assume such a role. I modestly analyze judgments, I analyze the legal system, and I make my judgment upon such analysis. I don't go beyond that scope. I mean, some would say, you see, that what I've been saying about the co-location arrangement in West Kowloon is pro-China. I'm sure many people would say, oh, you know, he's pro-China. Well, so be it. I mean, if they want to attach that label on me, that's fine. Many years ago, when I was very young and very green as a judge, they called me a green judge. You know, because I suppose all of us are, in one way or another, environmentalists. Good grief, if you don't value the environment, you don't value the air you breathe, you're not going to be a human, are you? So, I mean, these are broad concepts which I'm not capable of dealing with.
Next question, please. Yes.
Henry,
This is going to be a big one.
Thank you for the very provocative speech as usual. And since I'm one of the three who have read the judgment, and if I may pose the question in this way, the first principle of the rule of law is that the government's act has to be based on law. And that's what we start off by studying law about legality. So every government act has to be grounded in law or with legal sources. So the fact that government has spent billions of dollars on it doesn't answer the legality issue. Has that decision been based on law? Does it not go to the very basis of the rule of law? Is that decision based on law? And if so, is the court the only institution who could properly decide that question? And it is also well established that when the judiciary make a decision on legality, on whether the decision of the government is lawful, the consequence should not enter into the judicial decision, for otherwise the court is not really deciding according to law, but according to the consequence. So just to see how you respond to that.
Again, I think you have to read my essays. That is part of the problem, that the courts appear to have erected themselves so high above the rest of society that, you know, as I have tried to visualize it, the foundation of civil society in Hong Kong under the Basic Law are three equal pillars, the executive, the legislative, and the judiciary. One does not stand higher than the other. And it is not the function of the courts to apply their norms, their standards, their perceptions to judge the acts of the other branches of government. And in the name of legality, you can tear up, I suppose, just about every institution in Hong Kong. Now, I mean, are you then acting as a lawyer, or have you become a revolutionary?
Hi, Mr. Litton. This is Fanny Fong from Hong Kong Cable TV. I wonder what you think about the independence of prosecution decisions in Hong Kong. Years ago, we had the Saliao case, and then recently we had the DOJ's decision not to prosecute Mr. C.Y. Leung. And also the answers from Ms. Teresa Cheng doesn't seem to be very convincing to many people. I wonder whether you think prosecution decisions are made independently out of political considerations. Thank you.
Well, I've got 2 points to make. One is that the responsibility of the Secretary of Justice is derived from, I think, Section 63 of the Basic Law. And it's her responsibility to decide ultimately as to whether a prosecution should be launched or not. Now, that is her sole responsibility. In order to discharge that responsibility, she can, of course, if she thinks fit, seek help from outside. It's difficult for me, difficult to see the circumstances where that would be justified. Unless there was some legal issue involving complex financial transactions, say involving overseas jurisdictions and so on, where maybe there's not sufficient expertise in Hong Kong and you have to get, say, counsel's opinion from London or something of that kind. But generally speaking, the decision whether or not to prosecute is based upon the facts of the case. And no overseas counsel can help you analyze facts. What would, they would know far less than the Secretary of Justice. So, if you're commenting on something I think said quite recently by commentators in the I think South China Morning Post, that the Secretary of Justice had somehow failed to discharge her responsibility because she did not seek London counsel's opinion. Well, that depends upon her judgment as to whether there is any legal issue on which London counsel's opinion might be valuable. Now, what is the other point?
What is the same question?
Right. Well, I mean that's my answer.
I think some comments were not surrounding whether the DOJ is seeking advice from London barristers, but external barristers. Because in some cases, the DOJ seeks advice from Hong Kong lawyers as well.
Well, put yourself in the position of somebody who is under suspicion of some kind. Would it be fair on you to have these matters ventilated in the public media? Would it be fair? No facts have been proved in a court of law. Nobody has testified to anything. Nobody has sworn the truth of anything. You just have facts as you see them, true or false, and that is to be the substance of a debate in public as to whether you should be eventually, at the end of the day, prosecuted or not. Now, would that be fair on you? I would say grossly unfair. And if that is, the trend which you think should occur in Hong Kong, that there should be a public debate as to whether X, Y, or Z is guilty or not guilty, as a matter of media judgment, well, that would be a very sad day for Hong Kong.
May I add a comment, please? As a long observers of the people here in Hong Kong, unfortunately, they still had a mentality that think that British colonial government or anything British is better than local produced talented people. Why should we seek a British lawyer from London to adjudicate over the matters involving us? Are we not qualified to do our own judgment? I wish that people in Hong Kong would think seriously about this. Not everything British is better than Chinese or Hong Kong. Okay?
Could I comment? Oh, yes. But that's not the issue. Maybe the question that was put to Henry wasn't explicit. The issue here is not whether we seek British legal advice. The issue here is, in accordance with the Secretary for Justice's own declared public policy, where there may be a perception of bias or prejudice, you should address this particular concern by seeking outside advice, that is, outside the Department of Justice in Hong Kong. It can be a local lawyer. We're not talking about British. This is the issue at hand. And you're talking about a previous chief executive officer in the absence of a credible explanation from the Secretary for Justice. This is what the concern is about. And I think it's a perfectly legitimate concern. Next question. We were entering an interesting debate.
Yes?
Yes, please.
Let me continue the debate in a little slightly different worded question. Mr. Litton, do you see the role of Secretary for Justice should follow that of the British model, that the Attorney General was separated from the top prosecutor, so as to instill faith in the public that any prosecution decision would not be automatically reviewed by the Attorney General, because there's a separation, a firewall that keeps two decision separate. Yeah.
Again, this is really, I think, too broad and too amorphous an issue. It's really a matter of policy. Don't forget the role, the historical role of the Attorney General in Britain has evolved over a long period of time. And there are many anomalies in the British Constitution, such as, for example, the Lord Chancellor is a member of the Cabinet. Now, the Lord Chancellor, until quite recently, was the head of the judiciary. So you have the head of the judicial branch of government also sitting in Cabinet as the executive authority. Now, those anomalies in the British constitutional system is very difficult to, spin out a precedent to be applied to Hong Kong, and I don't propose to do so.
Yes.
Jane Lowe. I'd like to talk about a completely different topic. Now, I understand that you have a strong belief in the common law system, and you would like that the common law system to be advocated and supported after 2047. How would you advocate this system compared to the codified law which China is now running? Why do you think it's that much better?
Maybe my I was going to say conviction, but that's too strong a word. My wish, my aspiration springs from ignorance, because I'm not familiar with the set of laws, the entire set of laws that constitutes the laws as applied in the mainland. All that I know is that there are elements of law, such as joint venture laws, laws governing stock exchanges, and so on. But beyond those discrete areas, I'm totally ignorant. So if you ask me to make a comparison, I plead ignorance. I can't do it. And all I can say is that it seems to be the case that for Hong Kong to have risen to the position of a foremost financial center of the world and to continue to do so, seems to me that the foundation for that success is the common law. Now, if I'm wrong, then the entire thesis is wrong. So be it. But I imagine that most, if not all, judges would be of the same opinion as me.
One more question? Oh, yes.
Thank you. To return to the Secretary for Justice, I'm sure you know that the DOJ had informed the Hong Kong legislature, the Legislative Council, of its policy of when to seek outside counsel. And then I think it did this twice, in 2017 and 2018. It described 6 situations when it would seek outside counsel. And the Secretary of Justice doesn't seem to have acted according to this. I mean, so it seems strange that the department would tell the legislature, this is how we do things, and the Secretary does things differently.
I mean, that's your comment. I don't propose to comment on your comment.
I'll turn it into a question. You had said that it is entirely up to her to decide. But if the department has told the legislature, this is how we decide, it is no longer entirely up to her individually to decide, is it?
Well, I was just based on her constitutional position as written into the Constitution by the Basic Law. Article, I think, 63, isn't it?
And when the Department of Justice acts, it's acting in her name, I assume, especially when the department is informing the legislature of what its policy is, and it did it twice.
Well, I mean, yes, that sounds to me as a legitimate criticism from you. Now, nobody holding public office is ever without criticism. Even Anthony Chan has been criticized before, or many times. So, all right. I'm not commenting on your criticism. Excuse me.
More questions? Or, well then, I guess we'll close. Thank you very much, Mr. Litton. Souvenir.
Thank you very much.
It's not a tie because you may have one from before. So.
Thank you.
Yes.
Thank you very much.